So today we're going to dig into the revealing topic of, what's the difference between a trust and a will? And I must admit, I probably couldn't tell you the answers. So over to you, Whitney. Start. with-
Uh,
Well, why again? What's the big? Why is there so much ignorance around these sort of two simple terms? Why do you think that is in the first place?
I think that there's a common misconception that trusts are for the rich and the elite only. And the reality is, in this day and age, they're for the average human with $100,000 in some sort of asset or more. So essentially, a lot of people think that if they have their will put together and in order and executed, that that's going to protect their family from everything. Everything's clear. Everybody's going to do what it says, XYZ. And the reality is, when you have your will in place only, but it's not paired with a trust, you're actually still putting your family at complete risk for probate processes, a large amount of legal fees and court fees, long drawn out processes. So essentially, the difference between a will and a trust in layman's terms is the will tells the court what to do with your things, with your assets, and with the estate. And the trust bypasses the court altogether, generally speaking. Obviously, there could be disputes, or if you have a trust and you leave your assets out of the trust, they may still end up in probate. So essentially, your will tells the court what to do. So the court will make sure that your will is honored the way in which you want your things distributed. But the only way to get those things distributed, if you meet a certain income threshold, is by approaching the courts and filing to administer letters or letters testamentary, depending on the circumstances.
To start with the basic, how do you define a will? You kind of touched on it there at a high level, but how do you define a will on its own?
A will basically tells the people, one, who you want to administer your estate on your behalf, like who.
And it's from an individual. A will is in an individual's name. It's not in a family name or a couple's name. It's an individual's name.
Yeah, you can have a joint will between couples, but beyond that, you wouldn't be like son and father having a joint will generally. So yeah, it's pretty individualized. It's not uncommon for couples to have their own as well, but it's also a thing where couples can do a joint will. But basically, you nominate your executors, so who you would like to step in on your behalf once you are no longer able to act, and then a successor trustee or a successor executor, second successor XYZ. Then you specifically identify who your beneficiaries are and what you want them to have, whether it's a percentage of things split equally. You could also use your will to disinherit somebody. So it's kind of those type of circumstances. Essentially, you elect the parties that you want to act on your behalf as executors. You identify your beneficiaries and other special circumstances, such as like special gifts, if you want something to go to a church or animal sanctuary or whatever. If you've got dogs or cats or special animals that you know are going to need taking care of, you would nominate your animal executor in that case. So that's essentially what the will does. And then from there, once it's in place, you basically have what your family would need to follow your wishes, but they have to go approach the court in order to honor those wishes. So let's say that there is a real property involved and it's $500,000. If everybody has an interest, like say there's 3 siblings and the parent left it to the kids in equal shares. Well, that's great and all, but you still have to go clear that title. You still have to get the legal authority to sell the real property. So there's steps that the people have to take. And now, mind you, the mortgage isn't going to stop being due just because you've passed away and you've given them three equal shares amongst the three of them. So now they're going to have to figure out how to keep that mortgage current or run the risk of possibly facing foreclosure. Then they're up against a tight deadline with the courts, XYZ. So the will is actually just a Band-Aid for something that needs stitches. That's the best way to put that, I think.
So the will allocates the assets to wherever the beneficiary chooses to send them. But
Yes.
it's purely financial assets or assets of assets of whatever value. They're physical, tangible things. So for the areas of like resuscitation, the medical side of things, the will doesn't touch that at all.
No. That's a totally separate document. That would be called a medical directive, and that has absolutely nothing to do with your will. You should not be combining those legal.
No, so the will is purely to do with your assets and what happens to them.
Yeah. Not a power of attorney either, right? It's not going to give your husband or your wife or your partner or whomever, it's not going to give them the legal authority to make business decisions on your behalf, to pay bills, to access funds. So if you're incapacitated and you have a will, but you're still living, they're in limbo unless you've given somebody what we would call a power of attorney, which, by the way, very, very powerful documents. So those are not documents that you just go putting in place with anybody. You have to be very mindful of whom you give that kind of power to. It's generally used for husbands and wives, or wives and wives, husbands and husbands, couples, spouses. When you're, let's put it this way. I wouldn't recommend giving it to like just some boyfriend or a girlfriend, or, you need to be like commingling funds or like having responsibilities together to give away that type of authority usually.
Okay, so trust. What is a trust then? If that's a will, what's a trust?
Yes, the fun part. So essentially, all trusts should have pour over wills. Okay, so if you have a will, that is different than a pour over will, because the pour over will accompanies the trust. So there's two different kinds of wills in this case. Okay, so you're going to have a normal standard will if you don't have a trust. If you have a trust, you're going to have what's called a pour over will. And basically what that does is that it basically says follow the trust. That's basically what it says. And if anything gets left out, then we're pouring this document over, we're pouring this legal authority over those assets that may have gotten left out of the trust, which we'll get to in a minute. But basically it's an attempt at a blanket coverage of assets that may not have been included. Now, mind you, that still may not allow you to avoid probate. If you've left a condo out, or if you've left a second property, or whatever you've left. Like, for example, I was working with a client last week, and her brother had an $18 million estate, and he left everything out of the trust. And there are real properties in New York, England, LA, Orange County. So he has this completely global estate that's being probated right now because everything got left out of the trust. So funding the trust is just as important as having the trust. So when you're working with a seasoned professional, if they're not supporting you or educating you on funding your estate, I would recommend pushing back, asking more questions, or finding a different party to work with in that case. But okay, circling back to what a trust is. A trust is basically a legal document that you take your assets out of your personal name and you place them in this legal entity. It's a legal entity, basically. And so instead of you personally owning the asset, say the real property for $500,000, let's go back to that example. Now, dad knew that he needed to put this real property in the trust. Okay, so he took it out of his name and he put it in the trust. According to the trust, the way in which it should be distributed, it's in equal parts. Now the trust owns the real property. Dad's died, and now it's time to sell that so everybody can get their share in cash if that's what they want, or buy the other party out, or however they want to organize it. Everybody just has to make sure that they get an equal share. So let's say they decide to sell. The trust owns that real property. The deed is in the trust name, and the oldest son is the successor trustee. So that oldest son now has the legal authority to step in and sell that home and sell that home as a signer under a trustee. So
Yep.
he would be selling the home under John Smith trustee, or excuse me, John Smith trust, and then he would be executing his name as trustee. And everybody that needs legal authority has it to settle that estate quickly, avoiding probate, avoiding the courts needing to get involved. It's basically a safe place to put your things so that when you die assetless. That's what
Yep.
we want for you. We want you to die with nothing. That doesn't mean that you don't leave things for your family. We want you to have a legacy. And part of that legacy is making sure that the things that, the tangible things that you own, whether it be real property, art collections, animals, whatever you can think of, boats, yachts, whatever. We want those things protected, and we want your generational wealth to grow. And in order for you to do that, you have to make sure that these assets don't get tied up in your physical name.
Yep.
That's basically what the trust will do for you.
And what else beyond physical or financial or tangible assets goes into a trust?
You could put intellectual property in a trust. You can put your business. You can put anything that is important to you can go in there. So, I mean, you can't like fund a cat or a person to it, obviously, but it's just basically for everything that you own. Anything that you own all gets funneled into the trust. Like even in the trust and the pour over will, generally there's a clause in there that specifically says anything that's not mentioned or the remainder of my personal items all go into the trust and get distributed equally. Or maybe there's some people have a document for special gifts. So they may want certain special gifts to get distributed before the estate gets settled. So say grandma wants to leave Johnny $100,000 in a special gift.
Yep.
So grandma's has this in her documents with her trust saying $100,000 to Johnny, whatever. So the executor that's going to step in and settle this trust, they're going to go look at those special gifts and they're going to go ahead and distribute those. And then after those special gifts are honored, then the remainder of the estate basically gets distributed the way in which the trust calls for.
And the other documents we've talked about in terms of the power of attorney, is that actually under the trust?
No,
It's
no.
under the law. It's separate.
Yeah, it's separate. And one thing I also want to point out too, I had a client call me the other day and she was asking me about this trust that she was potentially a second executor to. And she goes, so then how do I go get it? Like, do I go to a building and do I give them paperwork and then they give me what I need? And so in her mind, this trust is like an entity or it's like a bank or it's a something,
Yeah.
you know, and a lot of people think like that. The reality is the trust is it's a legal document.
Yeah.
And then what you do is you turn around and then you put all of your things in that document's name or in that trust name. So you're going to go to your banks and you're going to give them a letter that we prepare in our packet, and it's going to specifically say on this day, here's a copy of the trust certification,
Yep.
and here's a letter saying that I need my accounts moved from my personal name over to my trust name, and then that allows everything to go into a pot. Basically, instead of having everything floating everywhere, when you end up in probate or you just have that will, everything's going to be floating everywhere. And you got to go find it. You got to go organize it. Then you have to petition, you know. So it's much more complicated of a process on many levels with just that will. And so generally, the trust is going to be established. And with that trust, you're going to want to be offered a pour over will, a power of attorney, which is another separate, all of these documents are separate legal documents, but they come into a package.
Yep.
So this is the healthiest estate package that you can look for is going to include the trust, the pour over will, the power of attorney, the medical directive, and then final wishes, final disposition. So you're covering all your bases.
Yep.
One, you're incapacitated but still alive. Excellent. Power of attorney's in place. Partner can go access, I was going to say access business bank accounts. Back that up. Partner can go access funds or act on your behalf in any way, under any legal authority through that power. The other thing that I mentioned earlier about that power of attorney is how powerful it is. And so oftentimes what people will do is opt to have that power of attorney have what's called a springing power. And the springing power will only take effect when you're incapacitated. So they won't have the power to act on your behalf prior to your incapacity. But once you are incapacitated but not dead, they can then act. So there's that. And then you're going to have your medical directive, which is extremely important.
Yeah.
You know, if you don't want to be resuscitated, you need to put that in writing. If you want to be kept comfortable, if you get late stage onset dementia or something like that, it's important for your family to know what to do. Because the reality is, if we are all blessed enough to make it to 70, 80, 90 years old, those are decisions that may affect us. And if you have lost your mind and you can't consciously give your family clear indicators of what you authentically want, it's extremely important to have those things identified in your medical directive. If your family finds you in a vegetative state and the doctors tell your partner that, 1% chance or whatever they may say to them, where they're faced with making a decision of like, do we physically let you go or do we hold on to you? Your input is very important because you'll find that your partner will do what they think is best for them. Like they're thinking, well, of course I don't want to hang out because I'm basically dead, but I'm not dead yet. I'm still stuck on earth, basically, right? So they may be thinking, let him go. And then your partner deep down might be like, no, let me hang out, and so you might be rolling the dice by not having those conversations and not getting them in writing as well. If you've had those verbal conversations with somebody you trust, like they can still advocate for you, but they may not have the legal authority to make the final decision for you either without that document in place. So those are all going to be very important documents. And then again, also, some people are very religious and some people aren't. Certain religions don't agree with cremation. Certain religions do. Some people might be, say, Catholic and still be okay with cremation. These are things that we need clarity to each other on. So when your partner has to bury you, will they be burying you or will they be, ashing you?
But the key thing here is that, you've got a will, you've got a trust. Those two things on their own are adequate, but they're not everything. You got the power of attorney, you've got to the medical directive, you've got to the final wishes. Those are the 5 key things you've got to have in place.
Yeah, I would say that, and by the way, somebody may sell you a trust without a pour over will. Terrible idea, but they'll do it. They're out there just trying to hustle the trust or whatever. But generally speaking, I would say from an importance perspective, obviously the trust is going to be end all be all. If you have nothing at all, at least get your trust in place, please. Honestly, and make sure it gets funded appropriately. I would say that's probably about, it's hard to put a number on this because it's like 100% important, but in the context of there are other important legal documents, I would say of importance, it's going to be like 65% trust. And then, the other ones are going to be important, but they're not going to throw your family into a legal nightmare. That
Priority 1 is the trust. Priority 2 is the will.
Number 1, number 1,000. I mean, it's such an important document to protect your family. People just don't get it. They don't understand the levels of protection that a trust comes with, and unless you've been in the muck of probates, which I have, and I've dealt with clients that I mean, honestly, it's hard enough to deal with the loss of your partner. And then you find out like, oh my gosh, I can't access their funds. I don't have the authority to sell the house without clearing them off the title. I I might face foreclosure, all
Yeah.
because they didn't have a trust.
Yeah.
You know, so yeah, trust is number 1,000 in terms of priority, and then I would say,
No, it's number one.
yeah, number one.
The number one thing you have to have in place is a trust. That is the be all and end all number one thing you have to trust. But if you're having a conversation with a professional, you need to make sure all five of these are covered.
Okay.
That's the way I would position it. Is that number one, you got to have a trust, but
Okay.
all five of these things should really be just done at the same time, because why would you not when you're doing this, making these big decisions? But
Right.
also you're leaving yourself exposed to so many different scenarios if you don't have these. So let's go back over that bit. But so the key thing is, so fundamentally, number one document is the trust. Is that right?
Yeah. So the number one document is obviously going to be that trust. If you don't do anything else, make sure that the trust gets in place. But reality is, all five of those documents should be done at once. And if you're working with a professional that completely understands the estate planning processes and your overall needs, they're going to be supporting you and covering all of those bases for you.
So the whole debate about, do I need a will or do I need a trust? There is no debate about it. You need both.
Yeah, you should have both. Absolutely. I think I want to like circle back to like, there may be instances where a trust may not be appropriate for maybe a high school, like an 18, 19, 20-year-old. But once you start hitting certain milestones and certain achievements, you certainly need to have these things in place. You're getting married, you're having children, you have built a successful business or a profitable business. Those things should be funded to your trust. That way, if you do become incapacitated, whomever has the legal authority to step in as either a co-trustee or a successor trustee can continue to make your business operate so it doesn't die with you or stop when you're incapacitated, basically. So other milestones would be, achieving a net worth of 100,000 or more, coming into an inheritance or a large sum of money somehow. There are certain triggers in your life that you should be thinking, all right, I need to have my estate in order. One way what I would compare it to is a life-changing event through insurance.
Yeah.
If you have qualified to change your insurance because you've had a life-changing qualifying event in the middle of your insurance term, you should probably be looking at your estate planning documents as well.
Perfect. So the whole debate about will or trust or poor over will or poor over trust, whatever, is basically you need them all.
Yeah. I mean, obviously, usually what happens, most people will start with a will and they might end there and they may think that they have it all together because they have that in place. But there are going to be other people, and through our education, we're going to help educate people and understand this as well, that once you hit these certain milestones or achievements, it's time to transition from that will. Now you need a trust. Now you need that protection. So generally people are going to start with a will and then they're going to graduate to a trust, or maybe they don't ever have a will because they already know that they immediately need that trust. And if you have a trust, you should have a pour over will with it, and that trust and that pour over will is going to revoke the previously executed will. So anything, generally what happens is in that trust there's going to be a clause that specifically says, this is my I can't think of the words right off the top of my head. This is my testamentary estate, and anything that was previously put in place is hereby revoked.
Right.
Is basically how that works.
Perfect.